I was there with my son 2 years ago. I've been there 3 times. It's a lot of fun.
Jimmy, do you have those numbers for me?
You are unmuted.
Timmy.
One more, Jimmy. You don't. Paul?
Will all the jurors please stand? Yea. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, in for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Jurors remain standing.
Jurors, can I have each of you raise your right hands, please? You solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God. Thank you. You can have a seat. May I call the case, Your Honor?
Please.
Your Honor, this is 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lyle for the Commonwealth. Good morning, Your
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, Jim. Jim? We all set? You just want them?
Yep.
All right, thank you. All right, good morning, jurors. My name is Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day looks. As you've heard, this is the matter of Commonwealth versus Karen Reed. It's a criminal case. First, I want to thank you for your patience here with us today, and thank you for our service. One of the most important duties we have as citizens of this country is jury duty, and we simply wouldn't be able to do this without you. So we do appreciate your patience here today. The Commonwealth alleges that at approximately 6 o'clock in the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these crimes in greater detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories that it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of murder in the second degree, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public opinion and interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all in this trial. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions all as a group, and then I'm going to ask you to fill out a supplementary questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give an immediate answer. After you fill out the questionnaires, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and your answers to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you will be excused during the impanelment procedure. Please do not take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and may be picked for another case. In a little while, I'll pose a number of questions to you as a group. You've taken an oath that requires you to truthfully answer these questions and all questions posed to you. I'm not asking you to take out your juror cards now. I'll ask you to do that at a later time. But if your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officers can read out your number. The fact that you answer yes to any of my questions does not mean that you're automatically disqualified from juror service. It simply means that there are matters that the lawyers and I need to discuss with you. If you find a question posed to the group to be overly intrusive, you may elect to answer that question at sidebar as well. I will have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding whether or not you're able to serve as a fair and impartial juror in this case. The lawyers are allowed to ask you questions for the same reason. There is no right or wrong answer. This is not a test. We are simply looking for your best and honest answer to our questions. I'm now going to have the lawyers introduce themselves, please. And when defense counsel introduce yourself, please introduce your client. So let's start with the Commonwealth, please.
May I?
Yes.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. I'd like you to meet my two colleagues.
Good morning, my name is Laura McLaughlin. I'm an Assistant District Attorney in Norfolk County, representing the communities in Norfolk County. Thank you very much for being here this morning.
Good morning, my name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. I just want to thank you for your time and attention and for being here.
Thank you. Mr. Jackson.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the honor and privilege of representing Ms. Karen Reed, who's standing to my right.
Good morning, ladies and gentlemen. My name is Elizabeth Little, and I also have the honor of representing Ms. Reed.
Good morning. My name is Robert Alessi. Thank you for being here and taking the time. I have the pleasure of representing Ms. Reed as well.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston and right here in Dedham. It's truly my privilege to represent Karen Reed.
Good morning, everyone. My name is Victoria George, and I also have the privilege of representing Ms. Reed. Good morning. I'm Karen Reed. Thank you for being here.
All right. Thank you. Jurors, I'm going to read you a witness list. It's very long. It does not mean that all of these people whose names I read to you will be called as witnesses, but you may hear their names throughout the trial. So please listen carefully because in a few minutes I'm going to ask you whether you know any of these folks. So it is alphabetical, but it's alphabetical by first name. Aidan Kearney from Jefferson, Mass. Dr. Isaac Wolf from South Miami, Florida. Alfredo Lopalato from Canton, Allison McCabe, Canton, Andre Porto, Massachusetts State Police Crime Lab, Andrew Klain, Bridgewater, Andrew Rentschler, PhD from Pittsburgh, Pennsylvania, Angela Malvone, Annie Chung, both from Canton, Anthony Flamati from the Canton Fire Department, Ashley Bell, Canton, Ashley Valier from the State Police Crime Lab, Brian Albert, Norwood, Brian Albert Jr., Boston, Brian Higgins, Sandwich, Brian Loughran, Canton. Brian Wanless, who is a retired from the Canton Police Department. Bridget Meehan, who is keeper of the records in Canton. Caitlin Albert, Easton. Lieutenant Charles Ray of the Canton Police Department. Chief Helena Rafferty, also of the Canton Police Department. Chris Van E., who is a PhD from Novi, Michigan. Christina Hanley from the Massachusetts State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford from the Norfolk County DA's office. Colin Albert, Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley from the Canton Fire Department. Daniel Wolf, PhD, from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell, who's from Los Angeles. Dr. Elizabeth Loposada, who is from Providence. Elizabeth Proctor, Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe from West Bridgewater. Francis Walsh from the Canton Fire Department. Garrett Wing from Green Cove Springs, Florida. Gary Fowler from Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss, Boston. Hannah Knowles from the State Police Crime Lab. Heather Maxon from Walpole. Erabito Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen, Vienna, Virginia. Dr. Irene Scorti Bello, who is with the Office of the Chief Medical Examiner in Massachusetts. PhD James Crosby from Jacksonville, Florida. Janet Reed, Dighton. Jason Becker, Canton Fire Department. Jean Demoulas, Canton. Jennifer McCabe, Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr., who lives in Braintree. Judson Welcher, also a PhD from a company called Aperture, LLC. Julie Albert, Canton. Julie Nagel, Canton. Dr. Justin Rice from South Weymouth. There are 2 juveniles in this case, both of whom live in Canton. The first one's initials are KF, and the other is PF. Caitlin Boudreau, Raynham. Karina Kolakithis from Canton. Katie Camerano, Canton. Katie McLaughlin, Canton Fire Department. The keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Mass State Police. Lance Mello from the State Police Crime Lab. Laura Sullivan from Pembroke. Laurie Cahill from Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lank from the Canton Police Department. Louis Jutras, Canton. Lieutenant Brian Tully and Lieutenant John Fanning, both of whom work for the Massachusetts State Police. Lieutenant Paul Gallagher from the Canton Police Department. Maggie Gaffney, Bonita Springs, Florida. Mark Lopalato, Canton. Margaret O'Keefe, Canton. Marietta Sullivan, Pembroke. Mary Souza, Dighton. Matthew Amory from Canton. Matthew DeSogra from Charlotte, North Carolina. Matthew Erickson from Grosse Pointe Farms, Michigan. Matthew Kelly from the Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe, Canton. Maureen Harnett from the Mass State Police Crime Lab. Megan Mariani from New York, New York. Michael Camerano from Canton. Michael Easter, Los Angeles. Michael Trotter from the Canton Public Works Department. Michael Wagner, Foxborough. Mike Maroli, Bridgewater. Mike Rushworth from Thompson Station, Tennessee. Natalie Wyweek Berschneider from San Marino, California. Nathan Reed from Raynham. Nicholas Bradford from Lorton, Virginia. Nicholas Curran from West Roxbury. Nicholas Kolakithis, Canton. Nicole Albert from Norwood. Norfolk District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police Department. Officer Nicholas Barrows from the Dighton Police Department. Matthew Haggerty from Somerset. Paul Mikowski from Melrose. Paul O'Keefe from Canton. Rebecca Bison from Canton. Rebecca Trayers from Norfolk. Dr. Renee Stonebridge, who is also with the Office of the Chief Medical Examiner here in Massachusetts, and she works out of Boston. Richard Green from the St. Pete Beach, Florida. Richard Donatno from Canton. Robert Gilman from Hull. Ryan Nagel from Canton. Sarah Levinson, Canton. Sergeant Brian Gallerini from the Needham Police Department. Sergeant Sean Good from the Canton Police Department. Sergeant Paul DiGiampetro, who Canton Police Department. Sergeant Yuri Buchanan from the Mass State Police. Shannon Burgess from South Lake, Texas. Cheryl Waugh from Canton. Sophie Herzan from the State Police Crime Lab. Stephanie Devlin, also from the Crime Lab. Stephen Mullaney from the Canton Police Department. Steve Nelson from the Norfolk DA's office. Stephen Bernstein, who's a keeper of the records from Stoughton. Stephen Ridge from the Boston Police. Stephen Seraph from the Canton Police. Stephen Scanlon from West Roxbury. Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty from Canton, Thomas Kelleher, Canton, Thomas Martin from Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton. The following people are Mass State Police troopers: Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark. Wendell Robery from Canton, and William Reed from North Dayton, Mass. So those are potential witnesses in this case, or people whose names you'll hear during the trial. Obviously, this trial is going to take a long time to try. The lawyers tell me that their best estimate, once we start with the evidence, is 6 to 8 weeks. We are in the process of impaneling a jury. We don't know when we'll finish that. We're toward the tail end of finishing that, but once we start, it will be a 6 to 8 week trial. That's our best estimate. Sometimes trials go longer, sometimes they go shorter. I can tell you that every day before we leave for the day, I tell jurors where we are, if we're on schedule, behind schedule, or ahead of schedule. And I've not had to tell a jury that we were behind schedule, and that's why we have that 6 to 8 week estimate. The schedule that we will have is we will start in the mornings at 9. We'll go until about 11 or so and have a break for about 15 or 20 minutes. We'll break for lunch, and you will have lunch delivered to you so that we don't have you walking into town center and coming back, because we want to make the most efficient use of your time. So we'll do that, and our lunch breaks will be shorter because of that. And we'll go until about 4 o'clock every day. So that's the schedule. There are some days off and some half days in that 6 or 8 week period. And if you're selected for a jury, you'll get those dates before we start. So that's our schedule and the best estimate of where we'll be. Now, it might help if I give you a preview about some of the basic law that applies to criminal cases like this. As I said, it's my job to teach the jury the law, but I don't do that completely to the end of the case. But for now, I'll give you a brief summary of some of the very legal, constitutional principles that will govern this trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. An indictment is a formal manner of accusing a person of a crime and bringing that person to court to stand trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth fails to do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. In a related important principle of law, the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether he or she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must decide whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, After you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is in the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve a fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision, so there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon any unsupported assumptions. Fourth, as you listen to testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of this case, I will remind you of these strategies and ask you to focus on the evidence instead of on any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing. Perhaps all of it is confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything that I've said. Why am I telling you these things now? Because we need to know if you're able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal principles. So you can take your white cards out now if you don't already have them. So I'm going to ask you several questions, and if your answer is yes to any of those questions, please raise your hand. But before we begin, I understand that sometimes we don't fill out the juror the confidential juror questionnaire forms that were sent to you completely. Sometimes we're in a hurry to get them in, or sometimes you might think that your situation doesn't apply to the question that's been asked. So if you're sitting here now and you realize that maybe you forgot to put in your age or prior employment, or whether or not you've had experience as a defendant in a criminal case, or a party in a civil case or criminal case, or as a witness or a juror, please let us know when you come up to sidebar. And if there's a blank that needs to be filled in and you didn't remember it and we catch it, we're going to ask you those questions. All right, so first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read?
963, 987, 1013, 982, 1034, 1018, 1017,
1038, 994.
Okay. Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers or the Norfolk County District Attorney's Office? If so, please raise your hand.
982,
Thank you. Do any of you or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. If you have seen, heard, or talked about this case, please raise your hand.
990, 1035, 1011, 978, 976, 987, 964, 984, 1020, 972, 1034, 1013, 971, 963, 1032, 982, 1036, 993, 979, 1003, 962, 1030, 989, 995, 988, 1030, 1005, 960, 1008, 968, and 983.
973, 1017, 1039, 1022, 1002, 1018, 965, 1027, 1021, 1015, 992, 1031, 970, 998, 986, 994, 1037, 1038.
Okay, thank you very much. Please raise your hand if you have expressed or formed any opinion with respect to this case. All right, thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If so, please raise your hand.
1032, 987, 978, 993.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical belief that would make it difficult for you to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand. I see no affirmative responses.
I'm sorry, there's one off to the right.
Oh, it's two.
1032, 966.
Okay, thank you. Would any of you folks have any difficulty following those very important constitutional rights that I explained to you? First, that the burden of proof rests entirely with the Commonwealth. Second, that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She can just sit in that chair and not ask a single question, not produce a single witness, and not testify on her own behalf. Anyone have any difficulty with those three very important constitutional principles? Okay.
983.
Now, I can tell you folks that after every jury trial, I talk to the jurors, and they always tell me that even though they may have not wanted to have jury duty, that they have found it to be an interesting experience, and many tell me that they find it to have been a rewarding experience. But I do understand that for some of you jurors, given the schedule that we have, serving on this jury may be a substantial hardship. And let me tell you what I mean by substantial hardship. Every civic duty that we have requires us to be inconvenienced in some way. This is much more than inconvenience. It means that there's something personal to you that means that you will be excused, but the person sitting next to you will have to take your place. I generally think of it in terms of you have surgery or vacation plans scheduled, airline tickets scheduled for the time that we will be in jury trial here. If you think you have a substantial hardship, please raise your hand.
990, 1035, 1011, 978, 967, 964, 972, 1020, 993, 1032, 991, 1005, 1010, 1012, 968, 1008, 960,
973, 988, 1022, 1018, 965, 1027, 1015, 992, 1031, 970, 1038.
Okay. Thank you very much. So I'm going to leave the bench in a minute or so to give you a chance to fill out the juror questionnaires. I'd ask that you not talk to anybody about the questionnaires, either about what your questions might be, or comments, or any concerns that you have about jury duty, either generally or in particularly this case, and please don't share your answers. So if you have any questions or concerns, you'll be able to talk to me about that when you come up to sidebar. All right, thank you very much.
All rise for the court, please.
You are muted. Goodbye.